working on this project, I felt a little bit like as if I were working on the ugly stepchild. The title is Federalism, First Amendment, and Patents, the Fraud Fallacy. I think I know just about everyone in the room, but I'm Robin Feldman. When I talked to con law colleagues, the reaction was close to running screaming into the night. Please don't make me talk about federalism. I hate thinking about federalism, and you want me to talk about federalism and patents. I can't think of anything I would less like to talk about. However, I have come to love this subject, and I hope that you will too. Though perhaps no arguments echo as strongly in U.S. constitutional history than those related to the role of the states in the federal union. Although scholars debate the extent to which federal and state powers were ever strictly separated, today the states and the federal government clearly occupy overlapping spheres. In this modern context of concurrent powers, the preemption doctrine manages the intricate places of overlap in areas ranging from banking to food and drug laws, immigration. States have the power to regulate a wide variety of commercial behavior that overlaps with the federal scheme. And it includes that states can require additional disclosure in the sale of securities. They can demand transparency for banking, for real estate transactions. They can regulate pressure sales tactics for businesses from automobiles to insurance. Overlap and concurrent powers are the norm in constitutional law, even where the federal government has staked out considerable territory, whether it's banking or immigration or other areas. In the realm of patent holder behavior, however, states have been confined to a fairly narrow space. Why does it matter? Well, government actors at all levels are grappling with the emergence of the non-practicing entity business model and contemplating various regulations that look much like regulations the states promulgate in many other areas. Such regulations might include, for example, transparency. Who are you? How do I identify you, for example, if I want to challenge your patents? What other entities are you and your patents related to, so I know whether I already have a license to use your patents? Other codes might relate to notice. For example, what am I supposed to stop doing if I don't want to take a license? And other regulations could be designed to curtail classic pressure sales tactics that the states have seen in many types of businesses. We in the patent industry tend to respond, these are terrible pressure sales tactics of NPEs. Other in consumer areas have seen things like this before. So in other words, does the state have the power to say, if you wish to engage in the business of asserting patents in our state, whether you're a non-practicing entity or a product company, here are the basic codes that you have to abide by. In federalism terms, the relevant question concerns the extent to which states can regulate the business of asserting patents. At present, courts and some commentators have concluded that outside of policing a very narrow band of bad faith behavior, essentially, the answer is no. My piece examines the logic for that limitation and for what I call the fraud fallacy. Now, fraud and bad faith are certainly valid terrain for state activity. However, rather than understanding fraud as an example of the territory in which a state may tread, I believe the Federal Circuit has grabbed hold of this fraud example and transformed it into a bright line beyond which states may not pass. I think it's somewhat reminiscent of the Federal Circuit's now discredited machine or transformation test, which was supposed to be a proxy for patentable subject matter. It's not that everything embodied in the test is wrong, or that the notion of developing a proxy was wrong. The problem lies in allowing the examples to take on a life of their own, disembodied from the underlying concepts. And in both machine or transformation and bad faith test, the Federal Circuit has picked out isolated elements and constructed a test as if these were the sole examples, rather than developing a test that embodies the entirety of the underlying concept. Now, there's certainly plenty of confusion in federalism doctrine, hence the reaction I got from so many con law scholars I talked to. But I think one thing is clear, and that is fraud remediation can't be the only permissible basis for state action. It can't possibly be right. So surely if I send a letter saying, if you don't take a patent license from me, I will kill your family, the state may have something to say about it. And that should be true even if I have a valid patent, and the patent license lawsuit would not be a sham, and I am not misleading you at all. I do intend to kill your family if you don't take a license. So all of those things, all those things were true. So there's no fraud, there's no bad faith anywhere. I'm not misrepresenting anything, I'm not misleading anywhere. A state has to be able to say, you just can't do that with your patents. This is not a business that we will respect. So the point is simply that even at a very superficial level, it cannot be that fraud and bad faith claims are the only domain in which a state may operate. Now, in case you think I'm setting up a straw man, I will tell you that at the last conference in which I presented the paper, which was at Berkeley, one patent scholar argued vigorously that in the kill your family example, the state would have absolutely nothing to say. It's a matter of federal law, and it would depend on what the Patent Act says, and that's it. So, sometimes straw man examples can be fairly useful for teasing out where the boundaries and the disagreements are. So now let me turn to how the lower courts got to this place of confining the states to fraud and bad faith. It begins with a set of 1960 Supreme Court decisions regarding the part of the First Amendment that gives you the right to petition government. These are known as the Pennington antitrust cases, in case that rings a bell. So in Knorr, the justices held that it is perfectly acceptable to petition the legislature to pass laws that will harm your competitors. And if you do this, you cannot be liable for an antitrust violation. The notion was that antitrust law shouldn't be allowed to chill the exercise of the right to speak to the government. That's Knorr. Now, I find it remarkable that the Federal Circuit's patent preemption logic rides on the shoulders of the Knorr case, because Knorr can be understood as celebrating states' rights. Knorr, in essence, said citizens should be able to tell their legislators how they want to be governed. Federal law should stay out of the way. That's I think, an accurate way to read Knorr. It's ironic that the Federal Circuit has dispatched Knorr to serve the opposite master. That is, preventing the states from responding to their citizens' concerns and saying federal law is going to stop you from that. Now, one can certainly understand why the Knorr line of cases was appealing to the Federal Circuit. The Supreme Court has set an extremely high bar in the Knorr line of cases for what constitutes inappropriate behavior in the antitrust context. The Federal Circuit wants to set an equally high bar for anyone who wants to say that a patent holder has behaved inappropriately. So Knorr was a nice place to borrow from. But missing from the Federal Circuit's logic is the Supreme Court's focus in Knorr-Pennington on the chilling effect that antitrust treble damages might have, and the justice is concerned that treble damages might dampen one's ardor for speaking to a court or to the legislature. That's not a logic that applies to the Patent Act. And in fact, the Federal Circuit tried to import the exact same set of doctrines into another area of patent law. This is in the fee-shifting, fee-award cases. The Supreme Court slapped that down last term in the Octane case, saying, we were talking about treble damages over there in antitrust. We're in patent land. This is different. We've also now had the Campbell versus Marvel case this term, with the Supreme Court emphasizing repeatedly that patent law is not antitrust. So the Federal Circuit's logic in these cases is resting on shakier and shakier ground. In addition to stretching the Knorr line of cases, the Federal Circuit supports its preemption decisions with some very thin and shaky patent cases. It begins with a short, and I do mean short, Federal Circuit decision from the early days of that court's existence, the 1985 Concrete Unlimited. So in Concrete, the Federal Circuit rejected trial court's finding related to a variety of things, including threats of litigation the patent holder had made. But there's almost no discussion. The Federal Circuit says a patent holder has the right to enforce its patent and the right to threaten infringers with a lawsuit, which is absolutely clearly true. There's no question about that. It doesn't, however, answer the question of the limits to which a patent holder may go in enforcing those rights, not to mention whether a state can regulate anything related to those threats. And that's the Concrete case. That's where we start in Federal Circuit. And with no more analysis than in Concrete, the Federal Circuit, in a case called Mallinckrodt, then declared that patent holder demands can't be challenged unless they're made in bad faith. This is where we start seeing bad faith in the Federal Circuit. Right, so to support the addition of this bad faith notion of sliding that into the test, the Federal Circuit cited concrete, which says nothing about bad faith, a 1913 Supreme Court case, which was an antitrust case, and some other lower court cases, which also didn't say what the Federal Circuit was saying. Mallinckrodt is a great case for this. It's got a bunch of stuff with supports that don't do it. It's been, on other grounds, disapproved sub salientio by the Supreme Court now, I think, in 2 different cases. Mallinckrodt is a wonderful case to study, and someday I'm going to do something on just on Mallinckrodt. But the lower court cases that were cited there, even though they were wrong, they were the wrong ones, they were part of an old line of lower court cases originating in the 1880s. And that line, if you look at it, can be helpful in some ways. The federal court held that federal courts can enjoin bad faith behavior by patent holders as a matter of equity. Paul Guglielmo, sorry for falling your name there, has done some excellent work looking at these cases. Now, the problem is the equity cases don't even consider the question of preemption. That's not the direction they're looking at. But nevertheless, these become a part of what the Federal Circuit has grabbed hold of to build this very shaky foundation and come up with its bad faith preemption rule. That that's all a state can do and nothing else. So if the Federal Circuit's logic is weak, if there's very little foundation there, it leaves a much more interesting and fundamental question, which is just how should preemption play out in this context? Because after all, patent law is a federal scheme. It can't be that states are free to rummage around in everything related to patents. That can't be right. So how do we know what a state can and cannot do? Bad faith isn't the line. What's the line that we should look at? So let me turn now to the preemptive contours of the Patent Act itself and what I think the Supreme Court would be likely to do with questions like this. So in general, the Supreme Court recognizes 3 types of preemption: express, field, and conflict preemption. The first category is easy. There's no express preemption language in the Patent Act. There's nothing that says states are preempted from doing anything at this point. The second category, field preemption, occurs when federal regulation is so pervasive, it's clear that Congress intended to foreclose any state regulation in the area, irrespective of whether state law is consistent or inconsistent with federal standards. You just don't get to go there. That's field preemption. Key battleground occurs not with either express or field preemption, but with the third area, conflict preemption. And with conflict preemption, the court is looking for either a problem where compliance with the federal and state regulations is impossible. You just can't do it. Nobody could do both of those. Or state law stands as an obstacle to something the federal regulations do. The Supreme Court has been less than crystal clear in deciding whether field or conflict preemption is the right level of analysis for the Patent Acts. So in a very strange opinion in the 1980s, Bonita Boat's case, Justice O'Connor used both field preemption language and conflict preemption language. She flips back and forth between the 2 of them in the decision. And the prior IP decisions from the Supreme Court had applied conflict preemption analysis. So it comes out very unclearly. Perhaps the most direct language in this line of cases, and what I suspect the court would do, is the following. It's from Aronson v. Quickpoint. And the justices said, commercial agreements traditionally are the domain of state law. State law is not displaced merely because the contract relates to intellectual property, which may or may not be patentable. And that's conflict preemption language. I think that's what the justices will take. So then, once we're in the realm of conflict preemption, not total field preemption, there are a lot of things that would concern the states in the legitimate exercise of their authority. So to begin with, the granting of patents in the Patent Act relies upon, presupposes a functioning state system of commerce and contract law. If you don't have this, if you don't have a state system for licensing, for contracts, for commerce, inventors are unable to form the commercial relationships necessary. No one says a patent holder has to be the one manufacturing the product, and we rarely think that forcing vertical integration, that one person has to do everything from idea to production, would be an economically optimal system. Societies may be better served if you see patent holders licensing for the creation of their products. So if the Federal Patent Act is predicated on local systems for licensing and commerce, the maintenance of conduct within those local systems is a problem. In addition, and as Paul has noted, states traditionally have played a role in disciplining abusive or improper assertion of legal rights. So in addition, these commercial, contractual, and legal assertion issues touch on other concerns that are distinctly local and that vary across localities. These are things like wage impacts, appropriate societal behavior, effects on local skilled and unskilled worker hiring, creation of industry clusters. This is why commercial, contractual, consumer laws traditionally are viewed as appropriate for experimentation for state jurisdictions and appropriate forums for reflecting and promoting local values. When I was thinking about saying this to you, I tried to figure out a nice clip that would show you the contrast between California citizens and how they would feel about the social values promoted by the Texas state legislature and vice versa. I never quite came up with the right way to show that, but I think somewhere in there is a nice way to bring out the notion that local and state legislatures respond to the issues of promoting the social values within their locality, and we in a federalism system encourage that for both the reflection of popular will and also the experimentation in legal systems. To paraphrase one constitutional law scholar, states must be left with something to do. So where would a state be limited? Most likely in the realm of things that are at the heart of the federal patent scheme. Things like requirements to obtain a patent. What's a valid patent? Definition of infringement, measurement of damages, procedures for challenging the validity of patent. These issues, validity, infringement, federal litigation, these form the heart of the federal patent system. State laws directed, those are much more likely to conflict with the federal scheme. And the most important point is the following. In moving through this preemption analysis, none of the expressions or explorations of a state's proper role suggests that a state should be restricted to the realm of fraud and bad faith. The logic for that notion seems to be spun largely out of thin air. Thank you, and nice to see more than the 2 or 3 faces we started with. The preemption really drives me. Let me tell you. Yes?
So I'm curious then about what the limits are of what states can do, and I want to explore that a little more. So let's say a state passes a law that says no patent holder can send a letter to a user of technology suggesting that that user of technology is liable for infringement and required to pay damages unless, and something about like the higher up the stream, the manufacturer's out of business or something like that. Basically trying to force patent demands away from users. That would seem to conflict with the Patent Act's ability to go after users of technology, and it would seem to be preempted. So I don't know that you would call it the heart of the patent system.
So I think what you're talking about, and correct me if I'm not going in the direction that you're going, but I think what you're talking about is is typical within constitutional law terms when you hit a question of whether you actually have a procedural or a substantive requirement. So is a state imposing something that is dressed up as a procedural requirement? In other words, of course you have to let people know, and of course you have to give this information. But our procedural requirement is so extreme that in essence it becomes a substantive requirement such that nobody can actually do it. So nobody can give notice of infringement, which is something that is mentioned in the Patent Act. No one can actually get in court. In that case, I think you would have an obstacle. You would have to step back a long way from something like that to satisfy constitutional demands. But I think that's the razor's edge that you're playing on. Yes.
So, and when you're talking about these concepts of preemption, I think it's helpful to sort of bear in mind that when we see the word preemption in these issues, we're sort of thinking about 2 different concepts, right? So the first concept is the sort of way the concept that constitutional law scholars would think about preemption, right? Field preemption, conflict preemption under the supremacy clause, which I think is what Greg's question is getting at. And then the second way in which preemption is sometimes used is this sort of unique way that the Federal Circuit uses it to refer to the protection that patent holders have under this doctrine that sort of has been developed from Pennington, basically, right? The protection for bad faith. the protection of patent assertions unless they are made in bad faith. And so I guess one other obstacle here, one other sort of counter argument would be interested to hear your responses to, is that there is a very robust body of case law in the lower federal courts, particularly the regional circuits, that have expanded Moore-Pennington immunity far beyond the original context of antitrust litigation, right? So they've extended it and given defendants protection against claims that are not antitrust claims. Courts have also expanded Moore-Pennington to give defendants immunity based not just on active filing litigation, but also because of pre-litigation. Immunity from liability based on pre-litigation. And in fact, the Federal Circuit draws pretty heavily in cases like Globetrotter on that body of law to say, well, in the same vein, patent demand letters are also protected by Moore-Pennington. So how would you sort of respond to that? Because I think saying that patent holders should be entitled to less than or immunity arguably goes against a pretty substantial body of lower federal court case law.
So I think there are two ways to approach it. There's a section of the paper that looks at that lower court body of case law that expands more into different areas. And I think you have to look very carefully at how it's expanded and why it's expanded. And I think none of those provide a good analogy for saying why in this circumstance it should be. So if you want to say that's a valid set of logic, and the Supreme Court, when faced with that, should follow it, you have to say why it fits here. And when you do that, you get back into these same things about it doesn't fit at all. It doesn't fit with what's going on in patents. There are reasons that it's been expanded there, even if it's just at the lower court level, the Supreme Court never pays any attention to the lower courts do anything. But it's still worth spinning, I think, that logic out, and there's a section that does that. But there's a second piece that also jumps out for me from the beginning of the way you were framing, which I think is critical. And that is, there is this federalism doctrine, and then there's what the Federal Circuit calls preemption. I have a piece totally on Hatch-Waxman called Ending Patent Exceptionalism. That's our problem. The Federal Circuit has got to stop believing that it sets its own legal doctrines and it doesn't have to pay attention to anything else in the law. Thanks very much.